Morning, everyone. My name is Jim Ahern. I'm Vice President of Sales here at Hausmann Johnson and a principal as well. Today we'll be discussing Director and Officers Liability Insurance, Employment Practices Liability Insurance, and hopefully if we have time we're going to include Fiduciary Liability as well. That's often a line of insurance that's included in the suite of executive liability coverages. So a brief background on myself. I've got 14 years of underwriting experience on the company side, combined with experience on the agency side here at Hausmann Johnson Insurance. Phil Holderness, who's joining with me, is Senior President of Executive Liability at RT Pro Exec. RT Pro Exec is a wholesale brokerage company that we partner with as an agency, place executive liability insurance, help out with the expertise that is needed in these specialty lines of insurance. And so Phil is a great resource and a great partner of ours. He's got 21 years of experience on the underwriting side at Chubb Insurance, as 11 years on the brokerage side. He worked with companies as large as Fortune 500, as well as small non-for-profits. So a brief disclaimer, we're certainly attorneys. This presentation is strictly advisory in nature, and so our attorneys advise us to put this disclaimer. So that's the extent of what I'll say there. And then we'll get right into it. This is Directors and Officers Liability. You are probably somewhat familiar with the difference between a claims made policy and an occurrence policy. Directors and Officers policies are typically claims made, simply meaning that a claim needs to be made during the policy term, in contrast to traditional life insurance, product liability insurance, which are oftentimes written on an occurrence basis, where the claim simply needs to occur during the policy term. The trigger under a Directors and Officers Liability policy, designed to business risk. Think of in another way as malpractice insurance for a business. Response to a claim arising out of a decision that has been made by the business go a certain way. In contrast to traditional liability insurance, triggered by bodily injury or property damage occurring. Defense costs are typically included within the limit of insurance, again, in contrast to traditional liability insurance, where the defense costs are outside the limit of insurance. The limit of liability are on a per claim basis, an overall aggregate, meaning the most that the insurance company would pay out in a given year, by Directors and Officers Liability Insurance. Well, there's different reasons. Probably most important is that as a legal entity, you can include and you can and you do yourself. Provides protection to your individual directors and officers. And then the corporate veil can be very easily pierced. All that's to happen is that a plaintiff needs to name that individual person. And whether there's any merit to that or not is a different story, but at least defense costs be incurred in defending that individual person. Furthermore, if you as an individual are a primary owner in the business and your own personal assets are tied up in that business, and business is paying those legal bills, net worth is effectively declining. The idea of purchasing the Directors and Officers policy and the cost of that is fairly reasonable compared to incurring it yourself and setting aside those funds to pay the defense costs and potential damages. So how does it work? Essentially 3 parts to a director's and officer's liability policy. See the Side A, Side B, and Side C types of claims in front of you. The vast majority of these types of claims are the Side B and the Side C. Again, the part that we're talking about with regards to individuals and protecting that individual's personal assets is the Side A, where that person is individually named. The Side B responds where the corporation is obligated to indemnify that individual, which is typically the case governed by the bylaws of the corporation. One we've been seeing a trend in is the Side A DIC coverage. Can you talk a little bit about that?
Thank you, Jim. As Jim, there are 3 sides to the D&O policy: Side A, Side B, and Side C. Every D&O policy is set up that way. There's some specialty policies that have evolved over the years, and one specialty policies is called the Side A DIC. Up until probably about 3 or 4 years ago, the Side A DIC policy was mainly purchased by publicly held companies, and the growth of that product really came out of business situations like Enron and WorldCom, where huge corporations literally wiped out by financial calamity, and most of which was their own doing. What the Side A DIC policy does is it provides pure protection for just the directors and officers in the event that there's no indemnification from the corporation, there's no more Side A, B, C D&O coverage out there. The DC, which stands for difference in conditions, that coverage essentially says there are very few exclusions in the Side A DIC policy. For example, the typical D&O policy has a pollution exclusion. That item is excluded because you can buy separate coverage elsewhere for that exposure. In the Side A DIC, there is no pollution exclusion. Keep in mind, the Side A DIC is really designed as the last resort, and it is just for the directors and officers. So it truly is sleep insurance.
Thank you, Phil. So who's covered by a directors and officers liability policy? Well, as we've discussed previously, individuals, directors and officers, but more as these types of policies have evolved, they've evolved to include more just the directors and officers. In particular, employees, members, an LLC, the individual members of the company. Because of how many people are now covered by directors and officers liability, we recommend to our clients that it's even more important nowadays to consider the limits of liability that you go about purchasing. As oftentimes your individuals collectively can do more assets they would have, years ago when only the directors and officers were covered. And of course, the entity itself and the entity's responsibility for indemnifying directors and officers. What is a claim? What's meant by a claim? Very simply, it can be a civil proceeding, a demand for money or injunctive relief from an attorney. Could even a criminal proceeding potentially, and a fraud potentially, or from a regulatory standpoint. Any of these items, we advise our clients to give us a call and have a discussion over it, and we can certainly provide some guidance as to whether it warrants a claim or not. We'd rather err on the side of caution and have a discussion over it.
Let's take the definition of wrongful act. The way that I look at the D&O policy, it's an all-risk policy. So it really is a form of insurance that covers everything that's not otherwise excluded. Wrong error, misstatement, misleading statement, act, omission, neglect, or breach of duty committed, attempted, or allegedly committed or attempted by an insured person or insured organization. So as you can tell from that general comment, an extremely broad policy. From the standpoint of loss, he's going to pick up the defense cost, and as Jim mentioned earlier, those are usually within the limits of liability. There may be, in some situations, there might be an additional limit of liability just for defense costs, but the costs, to my knowledge, have always been capped in the directors and officers liability policy. So the cost, damage judgment settlement normally picks up punitive damages and pre- and post-judgment interest. From an exclusion point of view, a minute or two ago I said this is an all-risk policy that covers everything that's not otherwise excluded. And I have to come clean. There are exclusions in the D&O policy. I tend to look at the exclusions, and the industry tends to look at the exclusions in 3 different buckets. There will be those exclusions that are in the D&O policy because coverage is provided by another form of insurance. The policy is really not designed to cover your general liability exposures, the bodily injury, the property damage. It's not designed to cover work comp. It's not designed to cover fiduciary liability, the ERISA. We'll talk about that, time permitting, towards the end of this presentation. It's designed to cover pollution. Now, having said that, it really is a form where nuance is very, very important. For example, most pollution exclusions in the D&O policy will say something to the effect of, based upon, arising out of, having anything to do with pollution, is covered under the D&O policy. However, bodily injury, property damage exclusion, that exclusion may read something along the lines of 4 claims of bodily injury and property damage. And the difference there is the pollution exclusion is what I call absolute. There's no way the pollution situation will be covered under a D&O policy. Another example where I use the word 4, that exclusion is designed to provide coverage for bodily injury or property damage that, let's say, would devalue the company. An example of devalue would be certainly in the pharmaceutical world, particularly if you're a publicly held organization, but privately held companies have the same exposure. If there is a bodily injury because of a pharmaceutical issue that causes the value of the company to be significantly impacted, and shareholders and or investors were to make a claim against the directors and officers, not for bodily injury or property damage, but for failure to supervise, failure to implement policy and procedure that would have prevented the bodily injury, those types of issues can be covered under the D&O policy. Let's take a look at the conduct exclusions. These are the personal profit, fraud, and dishonesty. D&O policy that I have ever seen has a personal profit and or a fraud exclusion in the policy. D&O claim that I've ever seen has allegations of personal profit and fraud or dishonesty. Every policy has an exclusion. Any I've ever seen has allegations. Heck, is there any coverage under this policy? The key, again, is how the exclusion is written. Exclusions for personal profit, fraud, dishonesty state that the exclusion only applies at final adjudication. Think of a lawsuit as a life. That lawsuit will have a life of 3, 4, maybe 5 years, from start to finish. The finish would be final adjudication. If, let's assume it's a 5-year lawsuit, if in year 4 and 2 months, the defendants, the directors and officers, say, we've had enough of this, we've got to settle, we don't think we've done anything wrong, but we're going to settle this D&O claim that alleges personal profit, fraud, and dishonesty. What you had is you've had 4 years and 2 months of defense costs paid by the D&O insurance company. And when it comes to settlement, because there is no final adjudication, the D provider will be participating in that settlement. There's an unbelievably large amount of coverage under the D&O policy for the business decisions that you make or fail to make. The issue with this coverage is it is high severity, low frequency. Not many people are involved in a D&O claim. It's not work comp, it's not like general liability where everybody understands those and the need for those lines of coverage. This is a line of coverage that you don't often hear about claims unless you have your ear to the grindstone or ear to the tom-toms out there and can pick up on things like that. But that's not in the personal profit exclusions apply or really don't apply in the event of a claim. The other main exclusions will be what we refer to as specific exclusions. So any pending prior litigation will not be covered. However, that prior wrongful acts will be covered as long as they are unknown prior wrongful acts. If it's a known wrongful act, the D&O insurance company would not want to cover that situation. A little bit of a nuance that really comes into play for the first-time buyer and really comes into play for probably the first 6 months of coverage. Insured versus insured. So the D&O policy is really not designed to protect one insured suing another insured for some type of mismanagement. There are exceptions to that exclusion, but that's not really the intent behind the policy. The policy is designed to protect the directors and officers and in certain circumstances, the corporation from outside claim activities. If you're a privately held company, you would see most likely a SEC, Securities and Exchange Commission exclusion or an IPO, initial public offering exclusion.
Briefly discuss the initial public offering exclusion. I might have some business in the audience that could potentially look at an IPO in the coming years.
Yeah, good question, Jim. The intent behind the IPO exclusion is necessarily to say if and when you go public, there's a way you'll be able to have D&O insurance. The intent behind the exclusion is that from an officer's liability point of view, as well as a director's and officer's liability underwriting point of view, a privately held company has a different exposure than a publicly held company. So if you're a privately held company today and you plan to do an initial public offering in 6 months, the idea behind the exclusion is make sure you talk to Jim, tell him you're going to do an initial public offering. Jim will be involved or get the D&O underwriter involved and say ABC Corp is thinking about doing an initial public offering. The underwriter will say that's great, it's good to see him grow. We're going to need a copy of the S1. We're going to want a conversation with the CFO and the CEO. We're going to find out who's taking them public, why they're going public, what they're going to do with the proceeds of the offering, et cetera, et cetera, et cetera. Because our risk as a D&O underwriter has now changed because this initial public offering and the new shareholder base that will be involved with the company. So be about an IPO exclusion, but don't think that you will never be able to have coverage for an initial public offering. We'll be able to get coverage for that event. It will come at a higher price, and it will come at a larger deductible amount because the exposure is greater. Conditions of the policy point of view. Jim talked about claims made. Really, some of the things that I want to talk about here are merger and acquisition provision. This policy will cover the named insured and all of its subsidiaries, generally defined as more than 50% owned by the parent company. Now, if an organization is involved in merger or acquisition activity, the D&O policy will automatically cover that newly acquired company, but there will be no coverage for the prior wrongful acts of the acquired company. And again, tell them just acquired ABC Corporation on July 12th. We'd like to make sure they're added to the D&O policy. We'll ask a few questions and do the rest. Exporting period comes into play in the event of a cancellation or non-renewal. May be as short as not available. It could be as long as 6 years. Something to be discussed up front, but advise in the event, again, of cancellation, non-renewal, or if you use your company, the directors and officers will want what's known as a tail or an extended reporting period. On held companies, most of these forms are duty to defend, meaning the insurance company will appoint defense counsel. That might be a downside, but keep in mind that the insurance companies do a lot of D&O claims, do work with good attorneys. These attorneys know their way around the legal world as well as the insurance world. The upside of the duty to defend is that when the insurance company assumes that duty, defend all of the allegations in the D&O complaint, which does provide an awful amount of coverage to the insured as well as to the insured entity.
Phil, do you want to briefly talk about there are some carriers that do offer a choice of counsel option?
Yeah. There are a few of the privately held D&O underwriters who say, well, policy will be duty to defend. However, if you want to defend claim yourself, you can tell us within 30 days or 60 days that you want to defend this claim yourself. We will agree to that as long as you select defense counsel that all is deemed as adequate, and you can work with that defense counsel and handle the matter on your own. Now, that's positive. You get to work with the defense counsel that you want to work with. The downside of that is the insurance company may not pay for all of the defense. They may allocate the claim because there could be some matters, there are some allegations that are covered and allegations that are not covered. Let's go to that bodily injury property damage exclusion again. Bodily property damage is not covered under the D&O policy. So if there was an allegation of bodily injury property damage and ABC Corporation assumed the defense of the claim, the deed writer would say, that's fine, but we will not cover any defense costs that are applicable to bodily injury property damage claim. It is a negotiation. It is not always a pleasant negotiation. Get into allocation matters. What I want to emphasize is that if a company does not buy a director's and officer's liability policy, you don't have to worry about the negotiation. It will all be the responsibility responsibility of the company.
Good point, Phil.
Thank you. Take a look at the sources of the D&O claims, and I'm not going to go through all of these, but the major sources are going to be shareholders and investors, partners and members, your clients, your consumer groups, other parties which might involve the government. It can involve others, those type of organizations. And when we get closer to the end of the D&O presentation, we've got some claim examples. Actually, we probably hit the claim examples on the next slide. Let's look at some of the numbers. This is a study that Chubb did in 2013, and to my knowledge, it's the most recent study. What it said is that over a 10-year period, approximately 30% of all private companies and 33% of all public companies have had a D&O claim. So my earlier point that this is a frequency, high severity type claim. Severity is borne out in the next bullet point, which says the average claim for a private company is almost $700,000. If you're a publicly held company, it's much larger than that. So let's take a look at some of the claim examples, and these aren't in slide format. We work with a company that's known as ERISA, and ERISA only offers D&O to privately held companies. We have a sister company that would provide D&O coverage to the publicly held company. So when it comes to a not-for-profit, I'm just going to read some of these claim examples to you. They're relatively short. Members of a country club allege negligence and breach of fiduciary duty against the club and certain board members stemming from the improper voting and election of its board of directors. Plaintiff alleged that due to the failure to follow proper voting protocol, certain board members were elected who mismanaged the club through self-dealing and other improper acts. That element, including elections and the defense, exceeded $100,000. So the actual examples from their claim files. Held company, 5 founders of a company who once owned 40% of it, also through the years a group of venture capital firms assumed management and engaged in a series of self-interested and dilutive stock offerings under terms that were grossly unfair to the common shareholders, which resulted in them, the common shareholder, the joint venture, the venture capital firms, resulted in the venture capital firms of receiving, let me flip that. The minority shareholders received less than $50,000 from an $80 million merger. So far, the defense costs have exceeded $250,000 in that situation. Let's talk a creditor claim. The plaintiffs filed a complaint against the individual D's and O's of a company, alleged that CEO, CFO, and COO conspired to use the plaintiff's services to furnish, install, and repair the company's equipment that was insolvent and was planned to file for bankruptcy protection. The cause of action included fraud, misrepresentation, non-disclosure, deceptive practices, and civil conspiracy. The settlement and the defense costs were over $100,000 on that. So one other one, actually 2 ones, misappropriation of trade secrets. A wholesale supplier and distributor of food products met with a sales representative of a new product line they are considering. This rep communicated that in order to develop a long-term exclusive relationship within the designated territory, the wholesaler must provide the sales rep with information regarding its business operations, customers, and trade secrets. Later, that sales rep opened her own wholesale distributorship within the same territory. That claim is also currently being defending, and the claim exceeded $450,000. Finally, an example of the government agency. The federal government sued the CEO and the president and the officers of an East Coast manufacturing company for pricing. The outcome. After the trial, the allegations were dismissed due to lack of circumstantial evidence, but defense costs and fees incurred were in excess of $750,000. So again, low frequency, high severity. Let's talk about some of the emerging issues in the D&O world. Cyber liability. I suspect some of the other folks at Hausmann Johnson have talked to you about cyber liability. This is becoming a D&O issue, particularly for publicly held companies, which means it will become a D&O issue for private and for-profit companies at some point in time. The idea is that the constituents, investors, shareholders, creditors, whoever, claim against the directors and officers for failure to supervise, failure to prevent, failure to protect the identifiable information that the bad guys got when there was a cyber breach or some other type of breach. We've seen claims already against Home Depot, and, the name's escaping me. It may have been Walmart, but I'm not. Target. Seen those claims, and we're going to see where they go. Increased government regulation. There's no question that there's more regulation out there, and in some of these situations, it is targeted to the individuals. The Jobs Act, that has raised exposures for privately held companies and the directors, officers, underwriters who work privately held companies. To be covered, it's just a matter of talking to your underwriter about the exposure under the Jobs Act, which is a kind of an initial public offering, but like an IPO light. There aren't as many filings, rules, and regulations, but there are still rules and regulations, and certainly the allegation of fraud could be brought in a Jobs Act capital raising effort. And then activism. There's some groups out there that have decided to target directors and officers over certain issues, i.e. climate change, by bringing claims against them, again, more in the public arena or their business practices. With that, we will move on to employment practice liability.
So, similar to directors and officers liability policy, these are claims-made policies, again, meaning that the claim needs to be made during the policy term. Because of the way that anti-discrimination laws have been designed, the employment practices liability policies have been designed to primarily protect the corporation, although they've evolved to also protect the individuals that are being brought into the claim as well. So, into this as far as the coverage triggers, but essentially the employment practices liability policies respond to allegations of discrimination, sexual harassment, retaliation in the workplace, hiring and firing practices, failure to promote. Defense is usually included within the limit of insurance, and the limits are on a per-claim basis with a policy aggregate, again, meaning the most that the insurance company would pay out in a given year. So why employment practices liability? You can see here the litigation is significant. The EEOC, the Equal Employment Opportunity Commission, receives between 80,000 and 100,000 complaints to its and it's very easy to file a complaint. An individual can go down to their local EEOC office and file that complaint, and the office is obligated to do investigation. And even with a no probable cause ruling, meaning you as an organization isn't found at fault, doesn't preclude the individual from filing a lawsuit and from you incurring defense costs. So about buying it, the employment practices liability policies have gained quite a bit more attention. They've evolved over the past 20 years. especially with the Americans with Disabilities Act signed back in 1990, prohibiting discrimination against Americans with disabilities, very similar to the Civil Rights Act of 1964. And this act also requires employers to provide reasonable accommodations. So again, presenting other exposure for you as a company, if you fail to provide reasonable accommodations, it gives the plaintiff counsel more ammunition. The other point I'd like to make, the laws have evolved to allow suits to include punitive damages. From the Employment Practices Liability policies to evolve as well, to provide coverage in cases. The policies have gained more recognition with regard to a couple of cases. These are getting quite old, but the Anita Hill, Clarence Thomas hearings, going back to Clarence Thomas's nomination in 1991, where he was accused of sexual harassment by Anita Hill while at the U.S. Department of Education. So just a couple of examples of how more attention has been brought to the issue. So who's insured? Similar to a directors and officers liability policy, the entity itself, you as a corporation, covered. I mentioned before, the policies have evolved to cover the individuals as well. So that includes directors, officers, employees, managers, and they provide coverage for independent contractors, temps as well as leased employees. Recommendation is always to address those issues during the writing process prior to issuing a policy. The important thing with regard to independent contractors is what your intention is. Do you want to extend coverage to those independent contractors? And how do you go about making known? Is that in your bylaws? Is it in your independent contractor agreement? You can structure the Employment Practices Liability policy to respond to those needs.
Look at the definition of claim, and you're going to see some repetition between the D&O, the EPL, and if we get there, the fiduciary liability. The main thing I want to emphasize on the definition of claim in an EPL policy is an EEOC administrative proceeding is a trigger under policy. So if an EEOC administrative proceeding is commenced, that has to be reported to Jim, to your insurance carrier, and at that point in time, there will be discussions about the insurance and the defensive matter and issues like that. Similarly, the letter from the attorney says, I represent Jane Doe. Jane has a complaint against you for harassment, for discrimination, for whatever the protected activity or class is. That also would trigger the definition of claim under a policy. So, and give Jim a call, talk to him, we'll get the insurance company involved. Let's take a look at the definition of wrongful act, and we're not going to go through all this. A D&O policy, I said it was an all risk. Definition of wrongful act under an employment practice liability policy is what we'll call named peril, but if you want to spend the time to read all this, you will see that it is a very broad definition of named peril. Third, employment practice liability. The idea that you have a customer, you have a vendor who feels that he or she has been discriminated against. Much larger issue in the hospitality world, much larger issue in the retail world. I remember years ago seeing an article about Dillard's, which is it's a department store like Macy's, where at Christmas time a Dillard security guard stopped an African-American woman and her 2 or 3 children as they left the Dillard store and accused them of shoplifting, put them in the security office, held them for a long period of time. And obviously the woman and the children were not involved in any shoplifting. And Dillard's store security person made a huge mistake because the woman was an HR manager. And yes, $1 million later, Dillard's got out of that situation. The Uber claim example, our economy is changing. We've started to see claims brought by disabled people against Uber for the ability of Uber to pick up a disabled person using the Uber service. So that's the third-party EPL claim example. So what's considered a loss? The main thing here, as Jim pointed out, is punitive damages. Got the plaintiff attorneys much more excited about these types of lawsuits, and the employment practice liability world had to respond, which is, the response was, it is pretty typical to have punitive damage coverage under the EPL policy anymore. Obviously, defense costs, damage judgment settlements are also covered. From an exclusion point of view, a lot of the things that are not covered under the D&O policy are also not covered under the EPL policy. So a prior claim, or prior litigation or quasi-litigation. So there's an EEOC complaint that's filed 4 months ago, and company is just now filing employment practice liability. That EEOC complaint from 4 months ago would not be covered under the policy. The main thing, one of the hot topics, I'm going to jump to the bottom, Fair Standards Act. This is a very hot topic in the employment practice liability world. Is typically not covered a Fair Labor Standards Act type claim, meaning the wages that are paid to individuals. What we are able to get is a small sublimit the defense cost of Fair Labor Standards Act. That small sublimit might be $100,000, it might be $250,000. The other thing that may happen is if there is an allegation of discrimination in conjunction with the violation of Fair Labor Standards Act, then there may be much more coverage under the employment practice liability policy, because this policy is also a duty to defend policy, which requires the insurance company to defend all of the allegations. So it's a difficult area right now for you folks. It's a difficult area on the insurance piece. The underwriters tell me that they feel the exposure is too great to handle right now. And if you think about it, these laws go back to the 1920s. I know Congress is talking about updating the laws, and I believe they are in the process of doing that. So maybe, fingers crossed, that situation will get a little bit better for business and get a little bit better for the insurance industry. Standard conditions, we've got conclusions up there, but that's actually be standard conditions. We're very similar to the D&O policy. Again, duty to defend, wage hour, is it covered, is it not covered? The hammer clause, let's see what that says is, if a plaintiff is willing to settle this EPL matter for $100,000, the insured says, no way, no how are we going to settle this for $100,000? The insurance company will say, okay, we won't settle this. We'll continue to fight this. But if we fight and lose, it costs us $200,000 to give this claim, then you, Mr. or Miss Insured, are going to participate in the settlement of that additional $100,000. So we settled it for $100,000. You don't want it for $100,000. We fight it, and then we'll lose $200,000. He says, we don't really like this, but we're okay with it. But if we lose $200,000, then we'll have to pay maybe 50%, maybe 30%, maybe 20%. So you might pay $50,000, might have to pay $20,000, might have to pay $10,000. Allegations, I think everybody's pretty familiar with the allegations in an EPL type claim. What we're seeing these days are retaliatory type claims. One of them, take a look at the statistics. As you pointed out earlier, they're getting between 80,000, roughly 80,000 and 100,000 per year. Let's say some of the claim dollars. This comes from jury verdict research. You can see when it comes to EPL, these are not easy situations when it's to jury verdict and the amount of money that can be paid to the plaintiff. These numbers do not include the defense costs, so they're just the jury verdicts. Issues in the EPL world, wage we talked about. Poaching. This is an interesting phenomenon. I've seen it twice. I saw it many years ago when I was on the underwriting side, and we've seen it in the press, where tech companies in Silicon Valley were accused of antitrust issues by agreeing to not hire either as employees, therefore keeping wages artificially depressed. That actually turned into an EPL claim for me years ago in the underwriting world, and it probably turned into either an EPL or a D&O claim for some of those tech companies. Social media, what can your employee say about your company on social media, and more importantly, what can you do about that? The key there is to talk to an attorney and make sure you have social media policy in your employee handbook. California, if you're out there, you're a tough employment practice liability venue. Sarbanes-Oxley and private contractors, what we're seeing is whistleblowing type activities and how those may or may not be covered under an EPL policy. Jim, it's 10 till 10. I don't know if we want to get into fiduciary liability.
Yeah, I think we'll briefly we'll address on a very high level. Similar to the employment practices and directors' officers' liability policies, the structure is very similar. Why? I think the most important thing here is that ERISA imposes personal liability upon fiduciaries in the business, those fiduciaries that have decision-making authority over the design of benefit plans, most importantly the retirement plan. Three duties that are imposed by ERISA: duty of loyalty, diversification, and non-deviation from the plan documents. And really those are the three truths for the fiduciary liability claim. If one of those is breached, that trigger the fiduciary liability policy. There's some confusion I find when working with our clients over fiduciary liability. There's a bond. The fidelity bond is required by ERISA to be placed at 10% of your retirement plan assets, up to a maximum of $500,000. So that's a separate bond, and that provides coverage for theft of those plan assets, in contrast to the fiduciary liability policy, which responds to claims alleging mismanagement or a breach of loyalty or duty and diversification or management of those plan assets. The other coverage line, there can be some confusion surrounding, is employee benefits liability. And this is a pretty standard coverage that we suggest our clients include in their general liability policies, and this simply responds to administrative errors or omissions in handling those benefit plans. So it responds to a mistake that's made. Well, very high level, again, very similar to D&O policies and Employment Practices Liability policies. Claimers, Phil, I don't know if you want to add anything there.
I think the main thing is most of the claim activity is going to come from the beneficiaries or the participants in the plan, and then the federal government, the Department of Labor, or the Department of Labor is going to be your regular in that situation. Wrongful act point of view, the ERISA, but it's any negligent act, error, omission in the administration of the plan. So employee benefit liability is actually covered under the fiduciary liability policy. However, fiduciary liability in the context of ERISA is not covered under the employee benefit liability. Then we get into what is considered a loss, again, very similar to the D&O and the employment practice liability. If we want to take a quick look at the exclusions, again, very, very similar. The one mentioned is benefits due. So it is actually a benefit due that's not going to be covered under the fiduciary liability policy unless there was a wrongful act that triggered the benefit due. Then the fiduciary liability policy will participate in that type of a claim. Standard conditions, again, very similar to EPL, more so than the D&O policy. The claims we talked a little about, the participants, the beneficiary, government, maybe the vendors. The litigations are going to be mainly ERISA violations, some conflict of interest, milling of funds, those type things. We do claiming examples, and again, those are taken from actual files and actual dollar amounts from the insurance company. Finally, I just want to mention on the emerging issues that the Affordable Care Act, also known as Obamacare, there is a large amount of that law which falls under ERISA. So ERISA and Obamacare were tied together. We said earlier, your employee benefit liability does not cover ERISA. So a good reason to buy fiduciary liability is the unknowns of Obamacare and some of the issues that we will be litigating in that world, continue to litigate in that world for probably years to come. The other piece would be that I wanted to mention would be the administrative cost of plans. Would be 401ks. The government, as well as participants, are scrutinizing the fees the outside vendors are charging the 401k plan, and we're starting to see some claims against big business for those fees. And typically, what happens in big business ultimately trickles down to small and medium-sized organizations also. That, I think we've got just a few minutes for questions.
To that, we received a question very early on in the webinar from Ryan, and he said, Jim said at the beginning of the presentation that you can sue yourself. What does that mean?
For that, that was in the context of the why buy directors and officers liability, and it was in the context of the corporation that can sue. The corporation is a legal entity that can sue and be sued. In the world of D&O, there's probably no reason why you can't sue yourself if you want to do that. I actually do have an example of that. But for a D&O policy, I talked about the insured versus insured exclusion. So the idea that a corporation can sue its directors and officers and collect under the D&O policy, the corporation can sue its directors and officers. Now, you're not going to be able to collect under the D&O policy for the situation. And
about a shareholder derivative suit?
Yeah, there is some of the exceptions would be a shareholder derivative suit, which is a claim that says that the shareholders are suing the directors and officers on behalf of the corporation. Corporation is actually the plaintiff, and if there are any monies paid, directors and officers have to pay back the corporation because shareholders or bondholders will be saying, we think you directors and officers have harmed the corporation, but don't want your money to put money back into the corporation. Well, in that situation, it becomes a Clause A claim because it doesn't make any sense for the corporation to indemnify the directors and officers for $10 million so the directors and officers can turn around and put that $10 back into the corporation. But the idea that you can sue yourself under the D&O policy and collect, that is not going to fly.
Do we have anyone else with a question? We just had a good question on our chat feature. If we get EPLI coverage, can we use our own attorney? Oh, we already addressed that one. Let's see if we can, that one was earlier.
Yeah, and again, that goes back to the choice of counsel, which can be negotiated up front during the underwriting process. That should be an important thing to know. And Phil talked about the pros and cons of doing that.
Explain some of the top factors to consider that might make our risk great as a company for D&O?
Some of the providers tend to look at in the D&O world is your financial performance. They want to see companies with at least a 3-year track record. The idea being that if you can hit your 3-year anniversary, then there's a chance you make 5 and 10. The balance sheet, they're going to look at the income statement, they're going to look at what business you're in, a manufacturer that's been around for 25 years, is deemed a stable account than a biotech or a life science company that has been around for 3 or 4 years. They'll be in. After that, look at the officers and directors, their experience. Look at the venue. As I said earlier, California is a tough place. California is tough for D&O as well as EPL. And then they'll look at your litigation history and merger and acquisition history. We learned as D&O people, mergers and acquisitions breed D&O claims. The more acquisitive you are, the less excited underwriters are about you. Not to say you can't get coverage. We're just going to talk about that.
And also just got a question from Mark. Who are the main insurance carriers in these types of plans, and how do you determine how much money?
Main companies are going to be names that most of you are familiar with: ACE, NG, Chubb, CNA, Hartford. Then there's a number of names you might not be as familiar with: Scottsdale, Euclid, you're familiar with it, maybe not in the D&O arena. Beasley. There's probably about 35 or 40 D&O underwriters we work with on a regular basis. For a privately held company, we do a D&O, EPL, Fiduciary Liability with ERISA, which is Scottsdale paper. They specialize in under 300 employees, and we see a lot of premiums for $1 million limit of liability. We will have an awful lot of premiums in the $5,000 to $15,000 range. So as you can see, this is not, in my opinion, it's not a real expensive line of coverage, given some of the issues out there the businesses face with D&O, EPL, and fiduciary liability claims. The bigger you get, the more expensive it gets. If you get public, it's more expensive. If you're in tough industries, energy right now is kind of tough. Real estate can be tough. Underwriters know that, and they adjust accordingly.
So part of this question, how do you determine how much coverage is appropriate? I would suggest considering all of those factors that Phil just described, and whether your business is faced with those factors. Consider the corporate assets that are potentially at risk. Consider the potential cost of litigation. Consider the personal assets of your members, because we mentioned before their personal assets are potentially at risk where the corporate veil can be pierced. Some great benchmarking resources as well that we often use as an agency. We can benchmark your business up against similar businesses of asset size and sales revenue in terms of the liability limits, deductibles and retentions, as well as premium costs. So if you're interested in pursuing that, I'd be happy to help you out with that.
We're running a little long, so if you have any further questions, please feel free to get in touch with Jim or Phil. And I'm going to pull up the poll, and we're asking that you just fill this out really quickly. Right after the poll is completed, I'll pull up the screen with the HRCI and SHRM credit information for everybody who's interested in that.
I'd like to thank everyone for joining us again today. I'm really pleased with the participation, and I hope it was worthwhile for everyone.
We'll be archiving this webinar. It will be available on our website in about a day. Also receive an email from me, Suzanne, and that will also have information about how you can get to the this recording. Feel free to contact me with any questions that you have. I was the person who set it up, so let me know.
Thank you.
No.